Dear students, in the last modules we had studied about preamble, constitution and the fundamental rights and duties we have been given by the Constitution of India. After studying this module, you will be able to learn about civil and criminal law, understand about different proceedings and punishments related to the two types of laws, know the justice system of India, discuss hand in hand basic laws under which the country is governed. First, we'll start with the introduction of civil and criminal laws in India. Civil law and criminal law are two broad and separate entities under law with separate sets of laws and punishments for offences committed under each of them. The distinct differences between criminal law and civil law are in the type of action against the defendant and the type of remedy or punishment sought. A civil case involves individuals in a dispute and generally ends in monetary reward, whereas the criminal cases are considered crimes against society and usually end in a prison, a hefty fine or both depending upon the severity of the crime committed, according to William Geldart. It is from the Introduction to English Law 146. The difference between civil law and criminal law turns on the difference between the two different objects which law seeks to pursue, redress or punishment. The object of civil law is the redress of wrongs by compelling compensation or restitution. The wrongdoer is not punished. He only suffers so much harm as is necessary to make good the wrong he has done. The person who has suffered gets a definite benefit from the law, or at least he avoids a loss. On the other hand, in case of crimes, the main object of the law is to punish the wrongdoer, to give him and others a strong inducement not to commit same or similar crimes, to reform him if possible, and perhaps to satisfy the public sense the wrongdoing ought to meet with retribution. Criminal law deals with acts of intentional harm to individuals. This in turn, in a larger sense, is offense towards the society. For example, breaking into someone's home is a crime due to the fact that this act not only violates the privacy and safety of the home's occupants, but also it is responsible for developing a fear of security, shatters the collective sense that we are secure in our homes. A crime is a deliberate or reckless act that causes harm to another person or another person's property. And it is also a crime to neglect a duty to protect others from harm. Civil law, it deals with disputes between private parties or negligent acts that cause harm to society. For example, if individuals or companies disagree over the terms of their agreement, or who owns land or buildings, they may file a lawsuit asking the courts to decide who is right and who is wrong. Sometimes employees are wrongly forced to leave their job. Hence, in this case also they can call for a lawsuit and resolve the issue. The failure to exercise the degree of causation that an ordinary prudent person would take in any situation may result in a negligence claim. A person may be held responsible for any damage or injury that is caused as a result of his negligence. Family law cases involving divorce, parental responsibility for children, spousal support, child support, and division of property between spouses or common law couples represent a large portion of the civil law cases. Some other example of civil law cases involve challenges to make decisions of administrative tribunals, allegations of medical malpractice, and applications for distribution of the estates of the deceased. Usually, the cases involve two parties, one of which is called the applicant or plaintiff. The plaintiff or applicant party is one who brings the legal action, while the party being sued is the defendant or the respondent. The courts may dismiss a case, or if it is found to have merit, the courts may order the losing party to take corrective action. Although the usual outcome is an order to pay damages, a monetary award designed to make up for the harm that has been inflicted. The state plays no role in civil cases unless the government launches a lawsuit or in the party being sued. Now next is differing standards of proof. The standard of proof is entirely different in civil cases versus a criminal case. The difference in standards exists because the civil liability is considered less blameworthy, thereby the level of punishments being less severe. Civil cases must be proven on a balance of probabilities. In contrast, in the criminal cases, the evidence is the most important thing required, and more evidence is needed to find the accused at fault. To convict someone of a crime, the prosecution must convince the judge on the basis of evidence that there is proof beyond a reasonable doubt that the person has committed the crime and should be punished. Judges and juries cannot convict someone they believe probably committed the crime or likely is guilty. That is, they must be at most certain. With the help of relevant evidences, the accused gets the benefit of any reasonable doubt, and this therefore makes it less likely that an innocent person will be wrongfully convicted and imprisoned. Next is omissions as acts. Generally, there is no legal duty to rescue, but sometimes there is a legal duty to act. A legal duty can arise in the following circumstances. First, by statute. Example, each citizen is required to file taxes completely and in time. Second, by contract. Example, a lifeguard or a nurse has a legal duty to act, that is, save a life. Third, because of the relationship between parties. Example, a parent's duty to protect children or a spouse's duty to protect the other spouse. Fifth is common law mental states. There exist 4 types of common law mental states. First, specific intent crimes. The term specific intent crime is commonly used in criminal law and designates a special state of mind, that is, intentionally or knowingly the crime is committed to fulfill the intent of the perpetrator. Examples of specific intent crimes: solicitation, inchoate defense; conspiracy, inchoate defense; attempt, inchoate defense; first degree murder, only first degree murder, not common law murder. If the facts only say murder, then that's common law murder, not specific intent. Other examples are assault, larceny, embezzlement, false pretense, robbery, burglary, and forgery. Then second is malice crimes. Malice in law refers to intent unlawfully to take away the life of a fellow creature in a case where the law would neither justify nor to any degree excuse the intention if the killing should take place as intended. Examples of malice crimes are common law murder or arson. Then is general intent crimes. General intent is defined the state of mind required for the commission of certain common law crimes not requiring specific intent, and it usually takes the form of recklessness or negligence. These crimes require the person to act and they need not have intended the specific consequences. Examples of general inherent crimes are theft, reckless driving or disobedience of traffic rules. Fourth is strict liability crimes. What is strict liability? In today's criminal law system, people are usually only punished when they have the requisite mens rea, which is Latin for guilty mind. In other words, we don't punish those that we don't see as morally blameworthy. If you intentionally break the law, you are seen as having a guilty mind. But there are a handful of crimes that don't require a mens rea. These crimes are called strict liability crimes. What is a strict liability crime? As mentioned above, a strict liability crime is a crime that requires no mens rea. That is, they are crimes that doesn't require you to intend to do something wrong or morally blameworthy. That is, these do not require a mens rea. In other words, you are held responsible regardless of your intentions. Even though you don't have the guilty mind that usually makes a criminal morally blameworthy, you are held responsible for your actions. Examples of strict liability crimes are speeding, running a red light, selling alcohol to minors. Now we will discuss about the elements of crime. The liability of a crime is expressed by the Latin phrase actus reus non facit reum nisi mens sit rea, which means an act is not culpable unless the mind is guilty. Likewise, a crime is composed of two essential elements as indicated. First is actus reus and second is mens rea. A voluntary act or omission, which is actus reus, is accompanied by a certain specific state of mind or the guilty mind, that is mens rea. That is, a crime is said to have been committed when a person commits a guilty act accompanied by his guilty mind. First, we'll discuss about actus reus. Actus reus, also known as the external element or the objective element of a crime, is the Latin term for the guilty act, which when proved beyond reasonable doubt in combination with the mens rea, that is guilty mind, produces a criminal liability in the criminal law jurisdictions. Next is mens rea. It refers to the mental element of the offense that accompanies the actus reus. Thus, in jurisdictions with due process, there must be an actus reus or guilty act accompanied by some level of mens rea to constitute the crime with which the defendant is charged. As a general rule, the criminal liability does not attach to a person who merely acted with the absence of mental fault. The exception is strict liability crimes. Accomplice liability. An accomplice is one who aids, advises or encourages the principal in the commission of the crime charged. They must also have the requisite intent that the crime has been committed. Accomplices are liable for the crime itself and other foreseeable crimes. Next is inchoate offenses. Inchoate offenses means incomplete. There are three categories of inchoate offenses. First is solicitation, second is conspiracy, and third is attempt. Inchoate offenses, solicitation. First rule, solicitation is asking someone to commit a crime. Second, note that under the common law, it is not necessary that the person solicited agree to commit the agreed. Third, if the person you asked to commit the crime agrees to do it, then it becomes a conspiracy and the solicitation merges and the only crime left when the other person agrees to do is conspiracy. Note, factual impossibility is no defense. Second is inchoate offenses, that is conspiracy. Conspiracy, the rule is conspiracy is an agreement with an intent to agree and an intent to pursue an unlawful objective. Conspiracy, the next is merger doctrine. Conspiracy does not merge with the substantive offense. On the bar exam, you can be convicted of conspiring to do something and doing it. Then is conspiracy liability for co-conspirators. Each conspirator is liable for all the crimes of co-conspirators if those crimes were committed in furtherance of the conspiracy and were foreseeable. Next is conspiracy agreement requirement. The agreement need not be expressed. Intent can be inferred from conduct. But note, if one person in a two-party conspiracy is merely finging agreement, the other person cannot be guilty. Conspiracy overt act requirement. The majority rule is that in order to ground liability for conspiracy, there must be an agreement plus some overt act in furtherance of the conspiracy. The minority rule and the common rule grounded liability for conspiracy with the agreement itself. If you are operating under the majority rule that requires an agreement plus an overt act, any little act will do to be an overt act in furtherance of conspiracy, even an act of mere preparation. If the question is silent, always apply the majority rule. If they want to test the minority rule, they'll say so. Withdrawal, even if it is adequate, can never relieve the defendant from liability for the conspiracy itself. The defendant can withdraw from liability for other conspirators' subsequent crimes, but he cannot withdraw from this conspiracy. At common law, a conspiracy requires two guilty parties. Thus, the acquittal of all persons with whom a defendant is alleged to have conspired precludes conviction of the remaining defendant. Next is inchoate offenses, where it is attempt. Attempt, which is general. Rule is specific intent. Second is overt act in furtherance of the crime. Note, attempt is a separately defined crime and is considered a lesser included offense of the completed crime. Statutory law allows the state to convict a person of attempt even if the crime has been completed. However, standard double jeopardy principles preclude a person from being convicted of both the attempt and the completed crime. Then next is attempt overt act. The overt act must be substantial step in furtherance of the commission of the crime. Thus, mere preparation cannot ground liability for attempt. Any act is furtherance is sufficient, need not to be substantial act, and mere preparation is sufficient. Impossibility is not a defense. Attempt defenses. Legal impossibility is a defense to attempt. Factual impossibility is not a defense. Now we would conclude this module with a summary. So far in this module, you have learned about first the two different types of laws under Indian jurisdiction, civil law and criminal law. Second, the differences in the crimes under them, their proceedings and also the differing standards of proof in them. Third, the different elements of crime and the relationship with each other. Fourth, inchoate offenses. And fifth, the 4 common law mental states: specific intent, malice crimes, general intent, and strict liability crimes.